Hello everyone, welcome to Court with Krissy. This pro se loves to file lawsuits. There's apparently a lot of them out there. He's also homeless and ran for Congress in New York. But the reason he's here today, before he was arrested on live PD and having pissed his pants, he was involved in a serious accident. He was riding in a golf cart taxi cab that was involved in a hit and run. And his name is not on the police report. I'm sorry, I don't mean to laugh. I think you're going to love this, so I hope you like it. Court with Krissy is now in session.
Good morning, everyone. Welcome to the 200th District Court. We are here this morning in cause number GN24-008968, Lewis versus the City of Austin et al. If we could just start with announcements. Introduce yourself. Let me know the total amount of time you believe the hearing will take and whether there is a request for a record or not.
Defendant, City of Austin Emergency Medical Services and Austin Police Department. I believe this will take about an hour and a half, and the city does not need a record for this.
All right.
Good morning, Your Honor. Scott Phillip Lewis, proceeding pro se, plaintiff. I think I'm only going to need about 20 or 30 minutes after all this. I requested 45. I think 20 should suffice, but I would like a record of this. Thank you.
Okay, that's fine. And Ms. Simon is here. Let me just confirm. I think she is ready to go, so we are on the record. And let's see, Mr. Roberts, I believe it's your motion, so you may proceed. And then Mr. Lewis, you will have an opportunity to respond. Go ahead, counsel.
Your Honor, we're here today about the city's request to declare Mr. Lewis a vexatious litigant, and require that he furnish security. The underlying case in this matter is related to a November 8th, 2015 car accident. Are you able to hear me adequately?
It could be louder. I don't know if you could sit closer to your microphone or if you could make sure your audio settings are turned up to the highest volume.
I think my audio settings are good. Let me see about the this. I'm a little bit of a quiet guy generally, so I'll just talk a little louder than is natural for me. We can make this work. The underlying case here is related to a November 8th, 2015 car accident in which there was a hit and run accident at about 3 a.m. on Rainy Street. And Mr. Lewis alleges that he was the passenger in a golf cart taxi. They were hit by an unknown vehicle that I believe it dropped its mirror or something like that. It was determined to be a white BMW, but there was not a lot of information about who the other driver was that actually hit this vehicle. The plaintiff filed suit on October 28th, 2024. So about 9 years after the initial accident occurred. And the basic allegation in plaintiff's the underlying lawsuit here is that there's something called a general offense report that the Austin Police Department produces when it investigates a crash or other, sort of any kind of incident. And this is sort of the APD's internal records related to these kinds of incidents. And Mr. Lewis obtained, I believe, quite a while after the accident, obtained the general offense report related to this November 8th, 2015 crash, and found that he was not named in the general offense report. And it's his belief that the reason that he's not named in the general offense report is in order to cause some sort of mental injury to him. That it's part of some kind of conspiracy by the city and various city employees to discredit him. I believe the theory is sort of that if other people were to request the general offense report, they would see that he's not named in it and think that he was not credible as a result of that. It's nominally pleaded as a negligence claims in this current suit. Well, there are three claims in the current suit. One is related to the APD's investigation of the crash and the creation of this general offense report. One is related to the Austin Emergency Medical Services allegedly showing up late to the scene of the crash. And the third is a conspiracy claim that is against both the city, the city departments, and the driver of the golf cart taxi, the company that owned the golf cart taxi, and then someone who's allegedly an eyewitness to the crash. So the first two of those are pleaded as negligence claims. The last one is a conspiracy claim. It's an intentional tort. And I'll get to the merits of those claims in a little bit here. But I think it's important for the background for the court to know that plaintiff is a serial litigant. The court is probably aware that Mr. Lewis was threatening to sue the court yesterday over if the court were to not strike the city's motion. Plaintiff has filed in 2024 alone. Plaintiff filed over 30 lawsuits, all pro se. And plaintiff has continued to sue people in Travis County and elsewhere during the pendency of this motion. I believe he had a hearing earlier this week related to a suit against a law firm that represented him in connection with another incident. He's especially has repeatedly sued the city and Williamson County over an incident involving his arrest on live PD. But he's also repeatedly sued the city over this incident involving the city's creation of this general offense report. He's also sued rehab centers, former employers, his ex-girlfriend, tax preparers, a car insurer, car, truck, and cabin rentals, several lacrosse organizations, and the New York State Board of Elections. And in this case, he's also suing the driver of the golf cart taxi, the golf cart taxi company, and others. He's sued a very, very large number of people over a fairly short period of time. And most of these suits have been in federal court. He's only recently been suing in Texas state courts. He's a resident of New York, who formerly lived in Austin. Most of his lawsuits have been filed in the Northern District of New York. And the Northern District of New York has subjected him to a pre-filing order that is in effect very similar to what he would be subject to under if the court were to declare him a vexatious litigant. The chief judge of the Northern District of New York has to review his filings before he is able to file suit in that. And when the city filed its motion, that issue was pending and he had a show cause order, but coincidentally, the Northern District of New York issued that pre-filing order on the date that the city filed this motion on January 6th, 2025. And the site for that, the cause number is 8:24-PF-00002 or 2025 Westlaw 33514. And Mr. Lewis has also expressed that his intent to repeatedly sue the city of Austin about this matter, regardless of the disposition of what happens today. And so the city requests that the court declare Mr. Lewis a vexatious litigant under Chapter 11 of the Civil Practice and Remedies Code. And so there are two elements that the court needs to find in order to determine that Mr. Lewis is a vexatious litigant. The first element, and this is under Civil Practice and Remedy Code 11.054. And the first element is that there's not a reasonable possibility that he's going to prevail in this litigation. And the second element, there are actually 6 different ways that one can satisfy the second element of this. And the one that the city is proceeding on today is that after litigation has finally been determined against the plaintiff repeatedly relitigates or attempts to relitigate pro se the cause of action, claim, controversy, or any of the issues of fact or law determined or concluded by the final determination against the same defendant as to whom the litigation was finally determined. And the basis for that is that there—
Mr. Roberts,
yes.
I can see my court reporter is shaking her head profusely. when people read, and you were reading from the Civil Practice and Remedies Code there, when people read, they have a tendency to speed up. And so if you could just slow down a notch or two, she would be a lot happier with you and me.
Yes, I will absolutely do so. I'm a fast talker, and I have gotten this reminder before. I will try to do my best on this.
Thank you.
The fundamental issue here for the second element is that Mr. Lewis filed the same claim against this it's not exactly the same, it's a very similar claim arising from the same incident in the Western District of Texas. That case has gone to a final judgment. I think Mr. Lewis is going to tell you that he's filed a number of motions that he is hoping will unsettle this final judgment, but there is a final judgment in this case. It was dismissed as frivolous by the Western District of Texas. Mr. Lewis filed an appeal, and he never filed a brief in the appeal and was effectively de-wopped at the Fifth Circuit. These claims, these elements overlap in that it's determinative of both of them that this claim is res judicata due to this other proceeding in the Western District of Texas. The elements of res judicata are a prior final judgment on the merits by a court of competent jurisdiction, identity of the parties or those in privity with them, and a second action based on the same claims as were raised or could have been raised in the first action. And this there's actually kind of a tangled procedural background to this prior action. So the prior action that makes this claim res judicata is a pro se lawsuit in the Western District of Texas that is cause number 1:24-CV-00461. And all the claims in that lawsuit were dismissed as malicious on May 24th, 2024. The previous lawsuit was kind of a hybrid. It's a sort of a weird background here. Mr. Lewis, as I mentioned, had been arrested for drunk driving on live PD at some point in 2019 and has filed a number of lawsuits in connection with that. And he had one that he was initially represented by lawyers and that he got some discovery that had proceeded a little bit. But ultimately, the judge granted summary judgment in favor of Williamson County on that claim. And the magistrate's report recommending that summary judgment be granted was issued on January 24th, 2024. But then the very next day, on January 25th, Mr. Lewis filed an essentially duplicative lawsuit raising the exact same claims related to this to alleged violations of his civil rights in connection with this arrest on live PD. And then a couple months later, on April 25th, Mr. Lewis filed the suit that contains these duplicative claims against the city of Austin that make this res judicata. And the May 24th, 2024 opinion that dismisses his prior claims addresses both of these proceedings, one that was completely duplicative and one that was duplicative but added all of these claims related to this hit and run incident and the city's alleged conspiracy against him in connection with this police report. Mr. Lewis filed appeals of both of these claims after they were dismissed as malicious and duplicative at the Western District of Texas through the May 24th, 2024 opinion. And the Fifth Circuit affirmed the dismissal of the first suit. I believe he filed a brief on December 2nd, 2024. And the Fifth Circuit dismissed the other appeal on November 20th, 2024 for one of prosecution because Mr. Lewis failed to file a brief in that appeal. The May 24th opinion doesn't really discuss the claims against the city in detail. And so in order to see that that these claims are essentially identical in the factual, what they arise from, it's necessary to refer to Mr. Lewis's petition, which is attached as an exhibit to the city's vexatious litigant motion. But the court does mention that there are claims related to this crash report or the go report issue, so describes them as frivolous. I mean, it's an implausible claim. This was a judgment dismissing the case. The city was a party to it. You can see the third element is met here, that the second action is based on claims that were raised or could have been raised in the first action. These are the exact same events and injuries that are at issue in that case. There's also a Tort Claims Act claim, which now Mr. Lewis is trying to proceed under the Tort Claims Act, but there are also 1983 claims against the city in that case. But in that suit, he stated in November 2015, plaintiff was involved in a hit-and-run accident on Rainy Street in Austin, Texas, leaving plaintiff with a concussion and traumatic brain injury. The police who were involved never followed up with plaintiff, seemingly attempting to cover up what had happened. And as in this case, he alleges that the accident and lack of police professionalism, follow-up, and transparency caused his mental disorders. He complained that on the night of the previously mentioned hit-and-run accident, the City of Austin Police and EMS took over an hour to show up to the scene of the accident, which is essentially the claim that he now makes against the emergency medical services. And as in this lawsuit, he alleges that the absence of his name in the police report was an intentional act that was designed to damage his credibility. He said when plaintiff was left out of the accident report and not followed up with, a 14th Amendment violation took place. Painting plaintiff as a compulsive liar was the goal. Austin Police Department intentionally left plaintiff out of the accident report. It's exactly what is now being alleged against the city here. And to the extent that there's any difference, it's just that the plaintiff has added more parties and accused them of conspiring against the city. The negligence claims here, plaintiff had reason prior to filing this lawsuit, plaintiff had filed a Rule 202 petition that the city responded to, and in that one he alleged that the city's actions constituted intentional infliction of emotional distress, and when the city responded to it, it pointed out that there's no waiver under the Tort Claims Act for intentional torts, and that it was not going to be possible for him to proceed on that theory. And so there was a jurisdictional problem that should lead to the Rule 202 petition being denied. Ultimately, Mr. Lewis never set the Rule 202 petition for hearing, but he's attempted to replead this in a way that it circumvents that jurisdictional issue. I think when you read the petition, it's very clear that plaintiff is still alleging intentional acts in these things. He states that it was intentional that he was left out of the police report, but then just denominates it negligence, but the court should look to the substance of those claims. He also cannot succeed in this lawsuit due to limitations issues. This is explained in the city's motion, and because of the res judicata issue is dispositive here, won't get into it fully. He says that he has the unsound mind exception applies to him and should toll limitations under this case. He has the burden of proof on that because limitations is jurisdictional against the city. He just supplies a conclusory statement about that. And a court in the Northern District of New York applying Texas law has already determined in a very similar case that the unsound mind exception does not apply to plaintiff's claims from this period of time, because plaintiff has filed a number of lawsuits concerning events that happened in the 2015 to 2017 period that would all be past limitations unless some sort of limitation apply or some sort of limitations exception applies to plaintiff. And so that's the first vexatious litigant element. Plaintiff stands no reasonable possibility of prevailing in this litigation. And the second element is that he is attempting to relitigate issues of fact and law that have already been determined against him in that Western District of Texas lawsuit. This is essentially, attempted relitigation of the frivolous claims that were dismissed by the May 24th opinion. And it has essentially the same fact issues are involved here. And they are both involved Texas Tort Claims Act claims brought against the city of Austin. The statute says after a litigation has been finally determined against the plaintiff, the plaintiff meets the element if they repeatedly relitigates or attempt to relitigate pro se the fact issues. And I just want to address that because it's something that I think the interpretation of that sentence can be a little bit confusing in that repeatedly looks like it could potentially modify attempts to relitigate. But several courts have considered this and said that you don't need to repeatedly attempt to relitigate. Just attempting to relitigate meets the element. And Forrest versus Vanguard Underwriters Insurance Company, 141 Southwest 3rd, 668, 670. The Texas Court of Appeals in San Antonio in 2024 looked at this and said Section 11.054 allows the trial court to find a litigant vexatious if she either repeatedly relitigates or attempts to relitigate a matter that has been finally determined against her. And several courts have examined this issue as well. I don't think it has come before the Third Court of Appeals, but the Houston First Court, the San Antonio Court of Appeals, Fort Worth Court of Appeals, and Amarillo Court of Appeals have all adopted the same reading that is the Forrest case has, and no Court of Appeals has adopted one to the contrary. And some additional citations on that. In Ray Smith, and that's 2024 Westlaw 901666 at page 2. That's the Texas Court of Appeals in Amarillo, March 1st, 2024. Interest of DB, 2023 Westlaw 4630624 at 7. That's the Court of Appeals in Fort Worth, and that opinion was issued July 20th, 2023. And Kim Wamid versus Transport Insurance Company, and that's 499 Southwest 3rd, 511, 533. And so all of those courts have agreed you don't need to repeatedly attempt to relitigate. Just if you were attempting to relitigate, you meet that element under the vexatious litigant statute. As such, the vexatious litigant elements are met, and the court should rule that Mr. Lewis is a vexatious litigant and subject to him to a pre-filing order in Texas state courts. And as part of the city's order, or as part of the court's order, it should require that Mr. Lewis provide security to reimburse the city for his costs if he wants to continue in this lawsuit. The authorization for that is Texas Civil Practice and Remedies Code 11.055. And the city proposes that the court require plaintiff furnish about $5,000 of security based on the time that the city has expended in responding to the case and the expected time needed to bring the case to a resolution through some kind of summary judgment motion. If this were to continue, the Office of Court Administration publishes a list of vexatious litigants and the orders, and the city consulted the recently issued vexatious litigant orders in Travis County that required plaintiffs to file security. There's a chart in the city's motion that shows the amount of security that was required in different cases. $5,000 is significantly below the median. It varies very widely. It's really within the court's discretion how much security to require or whether to just dismiss the case today. But the city requests that Mr. Lewis be required to furnish $5,000 of security given the circumstances of the case.
Okay. All right. Thank you, Mr. Roberts. Mr. Lewis, now is your opportunity to respond. Oh, I just need you to turn your video back on. And if you would unmute as well. Mr. Lewis, can you hear me?
Yes, I can. You hear me, Your Honor?
I can. Since you are proceeding pro se, some of what you're about to tell the court will be argument, some may be testimony. So I'm going to go ahead and swear you in. If you would raise your right hand. Do you swear or affirm the testimony you will give in this cause will be the truth, the whole truth, and nothing but the truth?
Yes, Your Honor.
Okay, why don't you go ahead and respond to what Mr. Roberts has said on behalf of the city?
Yes, thank you, Your Honor. First, I would like to begin from a quote from the great Abraham Lincoln. Truth is generally the best vindication against slander. That is what this case is about, is getting after the truth. Back in 2015, I had just recently moved to Austin, Texas. I was working a full-time job as a derivatives.
All right,
I was
Mr. Lewis,
working.
my court reporter is having a hard time hearing you. I can see that you're outside. I don't know if the wind is blowing, but if you could speak directly into the microphone and try to remain still so that you're not moving around, that causes a lot of background noise.
Yes, sorry, Your Honor. I just moved spots after I lost connection.
Okay. Why don't we, if you could just backtrack a couple of sentences and pick up there.
Yes, ma'am. I will go as slow as I can for your court reporter. Thank you. I was working a full-time job at Options Express, a subsidiary of Charles Schwab, and I was working coaching lacrosse gigs, paid gigs. I at Vandegrift Lacrosse Club. I was coaching a youth team and a JV lacrosse team and Iron Horse Lacrosse, which was a travel organization in Austin, Texas. I was FINRA licensed in the financials industry and with my Series 3, 7, 63, and 65 and working towards and taking classes towards obtaining my CFP. I was living life, loving life, and working hard at this time. Student loan. Everything changed on the night of November. That was when I was in a hit and run accident on Rainy Street. The impact cracked the windshield with my head. Respondents took a long time to respond to the scene. I didn't go to the hospital until the next morning, but I did go to the hospital. I was diagnosed with a concussion, and it is an injury that impacted my cognitive functioning. After this, as I continued to try to heal the injury and go to work, I only had 2 15-minute breaks and 1 30-minute lunch a day to do other things in my life before I went to a lacrosse practice after my job for the most part. I called continuously following up on what happened at the scene of the accident. Mr. Roberts says a mirror fell off and there wasn't much to go on. There were cameras all around. There were eyewitnesses involved. There should have been an investigation, and I expected to be followed up on such. I would continuously go to voicemails and leave voicemails where I would say, hey, I was in this accident. I would like to be followed up with. I would continuously get the runaround. And now Mr. Roberts wants to label me a serial litigant, but I can't help that I have been serially violated after this hit and run accident. And I am simply exercising my constitutional rights to a litany of violations that happened after this incident. The statute of limitations argument fails on Mr. Roberts' end because I didn't become aware that I was left out of the police report until within the last year. After almost a decade of not being able to find information about the accident I was in and not being followed up on, I did a FOIL request about accidents that happened with a golf cart on Rainy Street. That is how I obtained the police report. That wasn't until 2024. So I did not become aware of the negligence until within the last few years, and my statute of limitations is still good. In regards to other items that Mr. Roberts brought up that I just want to make the court aware of, I did not become aware that I was not in the police report until this last year. So there was no way for me to take any other action previously because I did not know what was happening. I would just not be followed up with. And then, like I said, I've been violated continuously since, which culminated in a live PD arrest 2 months before Javier Ambler was tased to death in Williamson County, Texas. My arrest happened on January 25th, 2019, where an edited and manipulated version of the arrest was broadcast to millions of people before I ever had a day in court. So I filed a lawsuit with counsel, with previous counsel, regarding this live PD arrest on January 25th, 2021. That arrest has to, or that lawsuit, excuse me, has to do specifically with the events of that night, the live PD arrest, the illegal broadcast, and then my shoulder was broken in the Williamson County Jail. When I found out about the arrest, I was assaulted and strapped to a chair after my shoulder was broken, and that's how my blood was drawn. Also included in that complaint is Brady violation claims about what happened with the destruction of evidence, which I think Travis County is well aware of at this point. So that was the first lawsuit. The second lawsuit that was filed was specifically against a hearing that happened on December 13th, 2024, where Judge Laura Barker instructed my counsel at the time on what to say to withdraw from the case. It had nothing to do with the live PD arrest or what happened in the jail. And I filed a third lawsuit, like Mr. Roberts said, against Williamson County. So this isn't continuously suing over the same thing, Your Honor. I'm filing different claims. And this next claim was regarding the hit and run accident. So my case is on appeal, and I don't want to get convoluted here with the different lawsuits. So the first lawsuit filed in 2021 was regarding the live PD arrest. That is currently in appeal, and those arguments haven't been considered in appeal because I'm still awaiting to get transcripts. I'm a homeless man, unable to pay court fees. I've proceeded in forma pauperis in my federal and state court cases. I'm looking to obtain transcripts so that appeal can go forward. The lawsuit where Mr. Roberts is saying that is being relitigated is a new lawsuit that was filed that ties in the negligence or the actions of 42 section 1983 claims against the city of Austin from 2015. The Western District of Texas did dismiss that lawsuit based off the first lawsuit being dismissed, saying I'm relitigating. I could have brought that up with problems, or I could have brought up those problems in previous actions. The issue with that is my first lawsuit had to do with events from 2019. All from 2019 and afterwards. And so the next lawsuit was from this 2015 hit and run accident. So for the Western District of Texas to dismiss based off of the same events, it's just logically deficient. They aren't from the same events. The first lawsuit's from the 2019 live PD incident. The second one's from 2015 hit and run, where my statute of limitations is still good. Furthermore, that case is in appeal. It is still in appeal. When Mr. Roberts says that it was dismissed for failure to file a brief, I did file a brief on September 11th, 2024. It was September 11th, 2024. It came back from the court clerk that I didn't cite properly. And I resubmitted a new brief that has not been accepted by the court, which is actually in motion for reconsideration right now before the Fifth Circuit with a 3-panel judge. So there is no, this issue hasn't been finally decided. The case number is 24-50453 is this one. It hasn't been ruled on. I filed a motion for consideration and I asked for oral arguments in front of a 3-judge panel in front of the Fifth Circuit because I want to bring this up, that this lawsuit is being dismissed over claims that happened 4 years prior, but they're trying to say it's from the same events. That's the huge issue there. So everything involved has not been finally decided. The live PD complaint still hasn't been adjudicated in appeal because I'm still awaiting transcripts. And the appeal that Mr. Roberts is basing res judicata off of is still in appeal right now. So that's that. In other courts, being vexatious, I just need to bring up the Northern District of New York and the State Board of Elections. I ran and collected signatures to get on the ballot to run for an independent common sense party in New York State for this year's general election. Proud to do it as a homeless man. I think this is not a political battle with the left versus right or Democrats and Republicans. I see it as the rich versus the poor. I'm living in a housing crisis in New York, and I am not ashamed to say that I am homeless at this time. And I have a right to run for Congress as a homeless man, and I did so. The litigation against the New York State Board of Elections is legitimate. The pre-filing order that the Northern State District of New York filed, the chief judge there, happened 2 days before general elections were meant to begin. It was meant to discredit all the work that I've done, and everything I filed is legitimate. Nothing is vexatious or frivolous, and I'm looking forward to showcasing that. 2 days before general election, I get an order to show cause to discredit all of my work. I responded, and the Northern District of New York did put a pre-filing order on it. The issue is it's not governed. It's section 1915 is the informa pauperis. There's a 3-strike rule, which I disagree with, is somebody who believes in civil rights, but that is the rules. That is the route the chief judge could have gone if she wanted to bar me from filing anything further. Her pre-filing order is not lawful, but I have followed it as an order from a United States District Court, and I have appealed it, and I'm not just going to ignore the court order. I'm going to go a different route, but it doesn't mean that her order is lawful and correct, and it is not. So the pre-filing order was put on me to try to slow me down and discredit me, along with everything else that I'm doing here. So these issues couldn't have been raised. And so so the last thing I want to say with the duplicative argument that is being made by defendant's counsel is I didn't duplicate claims. Parallel litigation is a thing. Litigation happening in federal courts as well as state courts at the same time. The claims I made in federal court have to do with federal law, 42 section 1983 with the 14th Amendment, and I did make intentional claims in that lawsuit. But the crux of it is the 42 United States Code 1983. The claims that I'm making here have to do with negligence. I do not make these claims in the other court. Counsel said there's negligent. I didn't make negligence claims. That is the crux of my arguments that I'm making here. And these were not brought up in previous litigation because I didn't bring up previous litigation with the negligence. I brought up intentional acts that could have occurred. And I want to bring up the Rule 202 disposition. And the reason why is I think that the city is probably negligent. But that means that there could be intentional actions done by state actors, which would fall under liability of 42 USC 1983. So that was the purpose of me calling that hearing, was I think we needed to get to more discovery to figure out who knew about this and who was just negligent. And after some time, I just decided to file the suit and go forward this way. But regardless, these claims have not been raised in the past. The dismissal at the federal court level just showcases a lack of logic being applied by the federal court there that I'm confident I will win on appeal. And so the first element there is that I don't have a success of probability on this complaint isn't met. There is, my statute of limitations is still valid. My negligence claims are legitimate and have not been brought up previously. And I'm not looking to relitigate claims. And if the district courts wants to make the argument that I am relitigating claims, then they prove my point with the second lawsuit, where I said that the hit and run accident had to do with the live PD arrest leading up to it, the civil conspiracy. If they're trying to dismiss my second complaint saying, oh, no, it's related to your complaint that you filed in 2019, and you should have brought up those claims then, in my opinion, they're admitting that the hit and run did have to do with the live PD, and I didn't bring it up in time, but I didn't know I was left out of the police report until the last couple of years. So I think that does cover it, Your Honor. I don't have anything else to add. Oh, I do actually. I'm sorry. The one last thing is I'm being nitpick here because I'm not an attorney, and I'm doing it this way. The legal malpractice I've encountered is legitimate, and that is what forced my hand with what I'm doing. But I just ask for the same things, from this court to defendant. Local Rule 2.2 says that he should have contacted me before filing this motion and got the nuts and bolts, and that there should have been a certificate on his motion, or the court had the discretion to strike. We could have discussed this. Mr. Roberts was confused about me filing the brief. He says I didn't file a brief. I did file a brief. I could have filled him in about what I'm doing in the appeals, in the appeal court, and that if I'm going to file a Rule 60 motion in the lower court if I need to, and it's not relitigating, it's litigating the same complaint using all the rules and rights I have available to me. We could have had this conversation before he filed his motion, but he didn't. And that's what really stirs me up, is I'm held to all these rules, but the attorneys aren't. And then when I bring it up, everybody tries to make it out that I'm throwing a temper tantrum when I'm just trying to hold the courts accountable, because I think we're having this hearing today at the taxpayers' expense because the courts aren't holding attorneys to the same standard. And so that's all I'd like to add. Thank you, Your Honor.
All right. Thank you, Mr. Lewis. And Mr. Roberts, it's your motion. You have the final say, so if there's anything else to add, you may do so.
I don't have much to add, Your Honor. I will mention, since Mr. Lewis brought up the certificate of conference here, this requirement is one that makes less sense with motions like motions for summary judgment or things like this that are there's not going to be a realistic compromise between labeling Mr. Lewis a vexatious litigant or not. We've discussed the circumstances around this extensively. Mr. Lewis, I understand, has some issues about his actions in federal court that we haven't fully discussed, about what he's doing to try to unsettle these final judgments. These are final judgments. He's not going to be able to unsettle them. These motions for reconsideration are going to be denied. Some of them have already been denied. The fact that they're pending does not do anything to make these judgments less final. And thus, Mr. Lewis should be declared a vexatious litigant and required to furnish security.
All right.
If I can just add, Your Honor, I'm sorry if I can. The appeals court has the ability to effect a final order. In this case, is currently in appeal. It's third judge, and if that's ruled against me, I can file a motion for rehearing federal rules of appellate procedure, and then I can appeal to the Supreme Court. And then on top of that, Rule 60 is a federal rules of civil procedure lever that is for final judgments. So I have not filed that Rule 60 motion yet, and I will. So if Mr. Roberts is going off a final judgment like he is, I think that showcases the game that is being played at the federal court. They're trying to dismiss it as being related, even though it's clearly not related, and there's no way that you can logically say they're related. And then when I bring up the hit and run, they're trying to say that this has been previously litigated. That is the game that Mr. Roberts and the city of Austin, and quite frankly, Travis County, are playing, and the public should be able to see that. There is the final judgment. If he wants to go the vexatious litigant route, he better make sure that judgment is absolutely final, or he has no leg to stand on. He could have filed a motion to dismiss and gone that route, but instead he wanted to go the vexatious litigant route, and he should have made sure that that there is no way that order is going to be changed, and there's a high probability that it will be, and if it's not, it just shows problems that are happening in our district courts and the Fifth Circuit.
All right. Anything else, Mr. Roberts, on that?
Nothing further.
No?
No, nothing further, Your Honor.
Okay. And I will just note for the record, since the local rule 2.2 has been brought up, I will just mention that requires folks to make reasonable efforts to confer about the date and time that a hearing is going to be set. And what the intent of that is so that people are all available when we're coming to court. And clearly Mr. Lewis is available because he not only is here, but he also requested in his own motion the ability to have a remote hearing, which I understand the city agreed to. So I don't have any 2.2 concerns as far as this hearing goes. I will take the motion under advisement. I will look at it and take a closer look to see whether I think the requirements of Chapter 11 of the CPRC have been met. And when a decision is made, you will hear from my court staff.
Thank you, Your Honor.
Seeing nothing else, y'all are excused from the virtual courtroom. Thank you so much for your time.
Thank you, Your Honor.